Hey, everybody. Welcome to Thursday night. John Skiba here from the Consumer Warrior YouTube channel. We're here like we are each and every Thursday night doing the live Q&A. Again, my name is John Skiba. I am a bankruptcy attorney and we'll call it a consumer defense attorney in the state of Arizona. I help people who are dealing with pretty serious debt issues. And the whole purpose behind the Consumer Warrior YouTube channel is to provide information and tips and strategies on how to deal with some of these big debt issues like debt collection lawsuits, bankruptcy, wage garnishment, all that kind of stuff. While I am a licensed attorney in Arizona, not licensed anywhere else. So if you need specific legal advice, you should not treat some guy on YouTube for that, but you should reach out if you're in Arizona. My number's here below. I can actually help you if you're from other states. I can refer you out to other attorneys. So feel free to reach out to my office and we can help you from there. So this week I thought I would talk a lot about maybe some bankruptcy questions because there's a few of them on the comments. One of my favorite comments this week is this one here, talking about Chapter 13 bankruptcy. This person said, Chapter 13 is like you being a wounded animal. All the vultures come out, lawyer fees, trustees fees, mortgage lawyer fees, even when it's not included in the actual plan. Chapter 13 is it's not an easy process. So there's two different chapters really that people file: Chapter 7, Chapter 13. Chapter 7 is what 98% of the cases are Chapter 7s. It's relatively short. Chapter 13 is a 5-year process where you're required to pay back a portion of the debt to your creditors. It can be, there's a lot of moving parts. I can tell you a lot of moving parts. And nationwide, there's only about a 35% success rate as far as people completing the whole 5-year plan, getting the discharge. So that number is a little misleading because I say the reason why a lot of Chapter 13 plans are not completed is because just life happens, I've had clients get divorced. They've had children. I've had clients die during a Chapter 13 case. And so a lot of these things happen that can influence it. So it's not quite as bad as being a wounded animal. And sometimes it's really the only choice. If you don't qualify for a Chapter 7 because your income's too high, or particularly if you're behind on a payment like a house payment, car payment, it's a really good option to be able to bring those things current. This person says, what can I do if a collection agency is still sending letters for payment after filing for bankruptcy? This is a good question. So if you file a Chapter 7 or a Chapter 13 bankruptcy, as soon as you file that with the court will immediately put an order in place that stops all collection. Now, this order is called the automatic stay because it automatically gets entered the second you file your case. So if you're still getting letters after filing for bankruptcy, two things. It's one of two things. Either one, they didn't get proper notice, or two, they're going rogue and they're just saying, screw that. We're going to come after you anyway. It's usually the first. It's usually that maybe they didn't get proper notice. I always give one kind of, shot across the bow saying, hey, look, you need to make sure to get this squared away. Make sure you have that you guys know that the bankruptcy is active. And then if they don't do it, you can actually go to the court, have the court sanction them and get them to stop what it is that they're doing. This person said, this is a debt collection lawsuit question, said, what do you do when you've ignored everything and you have court in 3 days? You clearly haven't been watching the Consumer Warrior YouTube channel because you would never wait until 3 days before court. The longer you ignore these situations, this is just good advice in general when dealing with debt. The longer you ignore it, the more likely bad things are going to happen. So if you have court, like a trial in 3 days, and you haven't done anything, it's likely you're going to lose. Usually most states have a disclosure requirements. You would have disclosed documents and witnesses and all that. And if you haven't done it up to 3 days before trial, they're just going to, they're not going to let you present those defenses. So this is just more of a cautionary tale that if you do get sued, if you're looking at bankruptcy, whatever it is, taking action is going to be the best way to get it dealt with so that you don't have to run into this situation where there's really it's probably not going to end well overall. So, all right. So, and one thing I failed to mention at the beginning, I do have a bunch of tutorials, things like that, the Consumer Warrior University. There's a link in the chat section. And if you have a question, go ahead and put it up in the chat section. We already have a few questions here that I'm going to be going over. And then also one of our sponsors of our weekly live stream, Solo Suit, I put a link there. They do a lot of great things with technology as far as debt validation letters, helping you file that answers so you're not in that situation where you're 3 days before trial and nothing's been done. Go ahead and check those links out. They are in the chat section over there on YouTube and on Facebook. All right, Travis Family Travels is here. Again, thank you for supporting the channel. This question says, we're in Arizona and we're served on a petty debt collection over a year ago. We responded and made settlement offers, which were declined, then nothing for almost a year. What can we do? Checking the court regularly, which is a good thing. In Arizona, at least you can check online and kind of see if anything's happening behind the scenes that maybe you're not knowing about. Here's what you can do is you can, if there is so petty debt tells me it's probably in the justice court system. It's under $10,000. In Arizona, if a lawsuit's in the justice court system, the rules require that from the date the lawsuit's filed, that there needs to be some type of judgment or trial scheduled within 10 months. So if it's been almost a year, or you're saying it's been over a year, I would file a motion to dismiss for failure to prosecute. You can look up the Justice Court Rules of Civil Procedure. Just Google Arizona Justice Court Rules of Civil Procedure. File a motion to dismiss for failure to prosecute. Some judges will still give them time, but if they've just done nothing, and that's what I would cite in the motion is if they haven't done any discovery, if they haven't filed a motion for summary judgment, if they haven't done anything, then go ahead and file that motion to dismiss. At a minimum, it'll bring the thing to a head and make them either go forward or the court will throw it out. And sometimes you'll get a judge who will say, look, you can't just file these things and park them there forever, creditor. You got to make this thing move forward. So, all right. Monterey MX says, I have $70,000 in unsecured debt, but my wife only has $7,200 and is current on that. Would a joint or individual bankruptcy be best? This is a good question. Question we deal with almost every day, particularly in states like Arizona. Arizona is a community property state. There are 9 community property states throughout the country. And typically, kind of in just kind of a general terms, what community property is it basically says that any debts or assets that you get while you're married are joint, regardless of whose name they're in. That's a really simplified version of it. There's, I get lawyers and stuff who are trying to say, no, well, what about this little carve out? In general, that's what it means, is that debts or assets that you get while you're married are joint. And so the danger in one spouse filing in a community property state is it's possible. So if I file bankruptcy, but my wife does not, then the creditors can no longer contact me and they can no longer contact my marital community for payment. Technically, they could contact my wife and try to collect it from her separate assets. Most couples in Arizona do not have separate assets. This is something to talk to an attorney about, but most do not. So I tell clients, well, look, we routinely file bankruptcy for one spouse all the time. Is there some risk? Yes, there's some risk, something that your attorney should explain to you. Do I think the risk is high? No, I don't. I've been doing this for over 20 years, and I can maybe count on one hand where it's become an issue. I don't even know if I can do that. At least I don't get a lot of feedback on it that it's any type of issue as far as one spouse filing, but it could be. And it's definitely something to talk to an attorney. If you're in a non-community property state, it's less of an issue just because the debts tend to be more separated, but definitely talk to an attorney about that one. But I can tell you routinely one spouse will file, even here in Arizona. So, all right, let's see here. And follow up saying you're referring to Chapter 7. Yeah, Chapter 7 is ideal for unsecured debt because it just wipes it out. There's no payment plan like in a Chapter 13. And so if you file and your spouse, doesn't carry all the debt, it's not in her name, then, you'd probably be okay just to file it in your name. So, all right. Says here, Destin says, if you live in Arizona, at what point should you be concerned of your wages being garnished? It's also a good question because a lot of people, they call me here in my office here in Arizona and they say, hey, I haven't paid my credit cards for 2 months. Are they going to come and garnish my wages? Are they going to garnish my bank account? The answer is no, because to garnish wages, they have to have a judgment against you. And to have a judgment, they have to sue you, serve you with the complaint and summons, give you a chance to respond, go through the whole process. And if they get a judgment against you, then they can go and request a writ of garnishment serve that on your employer. So as far as when should you be concerned, you should be concerned if they have sued you and they have a judgment against you. If they do have a judgment against you already, it could happen at any time. If they get information of where you work, and the way that the garnishment rules work and the laws work in Arizona, you don't get notice until after your employer already gets notice. So they send your employer the writ of garnishment, and then your employer is required to provide you with a copy, and then you get 10 days to object to it. So it's something where if the judgment's already out there, you need to be nervous about that because it could happen. And, there's never a good time, but it always seems to happen at the worst possible time for the garnishment to happen. So that's when you need to be careful of it. All right, let's see here. Tulip says, is it a requirement to include the entire household's income for Chapter 7 if you're currently unemployed and living with family? So I think what you're referring to here is like the means test. So Chapter 7, you do have to qualify for it. And the means test, what they do is they look at the number of people who live in your house, and then they look at your income. And we take an average over the 6 months prior to filing your bankruptcy to determine the total, as far as your monthly average, to determine if you qualify. So like, for example, and these numbers change throughout the year. I'm recording this in January of 2024. Right now, for an individual in Arizona, it's roughly $61,000 a year is the cutoff. Even if you're slightly above that, there's deductions sometimes we can do, and then it goes up based on the number of people in your family. And so the question here is if if you're filing Chapter 7, you're unemployed, you're living with family, do you have to include everybody else? So I can tell you, like, so let's say it's like we have like an adult, child of the house. So a 25-year-old college kid been living on their own. They move home because they're going through some financial difficulty. Do they have to include all their siblings, everybody else who lives in the home? I typically say no. There's two ways to do it. One is if the person is filing, you can say no, and you just focus on the income of the individual. However, if they're contributing money to you, like if the family was giving you $1,500 a month for your groceries and your gas, you could include that as income. So if you want to count the whole household, then you need to show how much they're contributing to you individually as the person who's filing for bankruptcy. In most cases, though, if you're just living there due to the financial situation, financial struggles, I just focus on the person who's filing for bankruptcy, unless other family members are actually giving them funds to help them get by. All right, Monterey says, my unemployment benefits will soon run out. How should I structure a 401k, IRA withdrawals if I will soon have no income? I'm planning on filing Chapter 7 in May. So I can tell you, if the question is, is that considered income as far as qualifying for a Chapter 7? Typically, no. The courts will count your income that you get essentially going into the 401k or the IRA, but they don't count it on the withdrawal. Essentially, that's just an asset that you're liquidating, that you're taking out. So that shouldn't count against you as far as trying to qualify for a Chapter 7, if I'm getting your question right. So Destin says, again, I live in Arizona. If you haven't been served anything yet, I assume credit companies can't get a judgment against you, correct? Correct, kind of. So what you've got to look at, what you got to be careful of, and this is why, my controversial advice that I tell people not to avoid service is because if they don't, sometimes, I hear this a lot. People will come in with a default judgment that they have, and they say, hey, I didn't even know about this. And it's because the creditor got permission from the court to do what's called alternative service. Sometimes that's sending it to the last known address that they have. Sometimes I've even seen it where they'll allow them to email you, and it's either the wrong email address or it goes to spam or whatever. You can look on the court's website, particularly if you're in Maricopa County, which is that's the Phoenix area. If you're in Maricopa County, the Justice Courts and the Superior Court have a case search function where you can plug your name in and you can't see the documents, but you can see the entries. And you can see if they're telling the courts that they've served it, or whatever it is. So you're saying there that you haven't seen anything yet. I would double check those websites. Just Google Maricopa County Superior Court or whatever county you're in, and see if there's anything on there that would cause an issue. So, all right, Shaka here. Thank you for supporting the channel. Appreciate it. What rule or law can be objected against with regards to personal privacy information being sold to third-party debt collectors? Do they have foundation? Well, it's a good question. The issue that we run into is that you usually contractually consent to these transfers. And, everybody's saying, well, when did I do that? That's the fine print in credit cards. The things that we scroll down online and just click, yep, I agree. There's usually a term in there, or even on the old school credit cards where you signed an actual contract, there's a term in there in almost every one of those that allows for what's called assignment or transfer of the asset or of the account to a third party. And so essentially when you're checking that box, you're signing your rights away. That you're letting them transfer the full file, including addresses, social security numbers, account numbers, balances, all that kind of stuff. So that's the issue that you have there, is that they're transferring it, and they're going to come to you and say, you know what, you agreed to it, and they're probably going to win that argument, because we call these contracts of adhesion. Essentially, they're kind of take it or leave it. You either sign the contract or you don't get the credit card. So you're kind of stuck with that once they do that. So hopefully that's helpful for you today. I think that's the end of the questions for today. But if there's additional questions, I always say put them in the comments. I do go back and look at them, try to answer them at a later point. And go ahead and check out the Consumer Warrior University, as well as the go check out the Solo Suit. They have a lot of cool things. I did a joint video with Solo Suit recently. We're going to do another one here in the coming weeks, which is going to be really good. So, all right, with that being said, I think we're going to close this out for Thursday night. Appreciate y'all checking in. We'll catch you